So welcome back. We are starting now panel number 6, and now we're going to discuss global networks and South-North cooperation. So we're moving away from country maps into a series of interesting larger issues, and we have panelists from all over the world, basically, who will be speaking from different perspectives in terms of how the North relates to the South and how global networks are structured. So basically, Philipp Dan is coming from Germany. He's a leading scholar in law and development there, has written a very influential book on the law of that governs international institutions that work with development, which I highly recommend. Then we have Álvaro Santos, who is Mexico Global South. Can I put you guys there? Okay. Who is originally from Mexico but teaches in the Global North. So he's a person who can offers reflections from those two places. Then we have Adrian, who is a Canadian who has been working with development for a number of years, has worked at the World Bank, is now involved with IDRC, has been deeply involved in the organization of this conference and can offer reflections from the global institutions. Then Fabia Fernandez, who is from the Global South, based in the Global South, and will tell us all about what's happening here after, and I think a lot of it will complement the country maps, right? And then we have Jad, who is the opposite of Álvaro. He's from the Global North and is now teaching here at FGV at the Global South. So this is just to give you a map of how we compose the panel, and without further ado, I will give the word to our presenters. We are just going to follow the order in the program. And I will strictly enforce the 15 minutes that you guys have, if I may, so we can try to finish 1 hour later the event. If the panel takes longer, then we are in trouble because then dinner gets messed up. Okay, thank you.
Okay, thank you very much. Is this working? Thank you very much. Thank you very much. First of all, of course, for the invitation. It's been a great learning experience for me in the past 1.5 days. I have to say it's somewhat ironic that you invited me to come here as somebody coming from Germany. In two respects. For one reason, perhaps because Germany is rather a developing country when it comes to law and development scholarship. So it's certainly not a field which is very developed there. But the other irony, of course, is after that discussion which we had before the lunch break, that Germany is the heart of darkness when it comes to formalism and the ground zero of sort of formal legal thinking. So perhaps that sort of throws up some sort of perspectives on what I will be talking about. My presentation will proceed in 3 steps. I want to first actually continue our mapping exercise by trying to map law and development scholarship in Germany in particular, but in continental Europe perhaps more generally, just to understand where I'm coming from and what I will be saying afterwards. And then secondly, describe a field in which I think formal and non-formal approaches to law and development can actually be combined, because that's a little bit the sort of the thrust of my argument, or at least one part of the argument which I want to highlight after this last session. And then in the third step, I will try to continue with thinking about South-North cooperations and how this sort of can be perhaps improved. Okay, so starting with the first map of law development in Europe, what's the state of the art there? Now, this is really a complex kind of issue because it's a complex mix of methodological, institutional, and thematic aspects. So it's not really easy to explain where is what and why. So if we are talking here, and that's what we have been doing over the last 1.5 days, about law and development in the vein of law and society scholarship as understanding that it's mainly using empirical socio-legal methods and a critical approach, then obviously, or not obviously, but in Germany or in continental Europe, you will not find that at a law school. Law schools are teaching schools where you teach young students to become, at the end of the day, advocates. So law schools are very much dominated by a formalist approach where you have much less of interaction with other disciplines. You will find law and development kind of scholarship outside the law schools. You find them in the social sciences department, and that perhaps sort of reminds of what Arun said yesterday about India, that you have in the law schools you will not find that kind of scholarship, but you will find it outside. We might also sort of wonder why you find law and development scholarship in US American law schools. That also tells us something about the audience of these law schools and in which law schools this is taught or not. So I think there is sort of a mix of things there. So this is an institutional perspective, but that doesn't mean that there's no engagement with the theme of development in Europe, and there's no tradition of engagement with that theme. One tradition, and actually very important for the European continental scholarship, is the French sort of approach of the droit international du développement. So basically an international law approach to themes of development. Those themes, this scholarship started in the 1960s, was highly influential and innovative at that time. It was dominated by French-speaking scholars from France, Michel Virali and others, but also from Northern Africa. So this was actually the attempt to rethink international law from a development perspective and use formalist approaches or formalist structures of arguments to sort of provide arguments of how to sort of reinterpret public international law in order to aim at certain sort of policy objectives. So this is a traditional European approach to the topic of development, an international law approach from that time. This approach, like the law and development approach in the US, went into hibernation in the late 1970s. You can actually sort of point it to the same date, perhaps, as in the US. When we were talking so far, we were always talking about the Trubek-Galanter peace of 1974. In 1974, obviously something else happened. The new international economic order was adopted by the United Nations. And that was also perhaps the high water mark or the high point of third world influence on international politics. And afterwards, there was a certain sort of realization that they would not be able to sort of follow up on that agenda or will not get through this. And there was setting in a certain fatigue, a certain sort of frustration also, at least that's what I hear from older law and development scholars in Germany, that in the late 70s and 80s, there was just no point. There was just frustration about where the political system was going. Now, as here you have a reawakening, a renaissance of that field after 2000. And you have that on both levels. So first of all, you have a reawakening of international law of development. And I think the TRIPS agreement marks one of those watershed moments where it became increasingly clear that the consequences of that agreement are disastrous for the developing world, and that you have to sort of that you have to engage with that. At the moment, we are discussing really intensely in Germany in investment law. From a political perspective, but also from a legal political perspective, free trade agreements with Canada and the US. And that is basically the pretext or the follow-up on development discussions here. But you also have new topics that are picked up by mainstream, or at least mainstream academia, topics like legal pluralism, comparative law approaches, or post-colonial dimensions of international law. So there is, since the 2000s, there is a sort of a new attention to those kinds of topics and themes. And you also have a methodological opening in Germany or continental Europe. And this is an opening up for sort of interdisciplinary approaches, as we call them, sort of approaches which combine or try to combine legal analysis, formalist analysis in our area of the world, with empirical or theoretical methods. So the interesting thing here is that those kind of interdisciplinary approaches are not only from that time. They have actually sort of started to be developed and used in German legal academia from the latest from the 1980s, and they normally came from environmental law. So there was a big discussion on why aren't our environmental laws not working? What about the enforcement of these laws? And this has sort of initiated a sort of pretty fundamental discussion of sort of how do we deal with compliance problems and the law. And this can also now, of course, be sort of picked up by other areas. So you have this opening on the thematic side, and you have this opening on the methodological side, and now you can actually say that even law and development scholarship in that American sense is coming to the law school. So I'm teaching now actually not in Gießen anymore, but in Berlin, and I will probably be the first to actually teach a course called Law and Development in the law school. And I'm sure I will not be the last. So there is a sort of a much broader acceptance now for those kind of topics to come from. So this is the first step. So this is the background to where the sort of the mapping of the European kind of dimension. Now, you might wonder, sort of as perhaps last point here, why is formalism entirely bad? I want to pick up this question which Alvaro actually asked in the last session, and I don't know whether it was a trick question or whether what it was. But I really think that to me you have to. For me, it's not an either-or choice, or at least I reflect here of the German discussion. I think it's more a question of how you can combine those approaches. And one sort of slogan that is then used very often is law in context, or actually sort of an approach where you do pay attention to formal structures of the law, but you are also aware of the fact that this is not the end of the story, but you have to engage with other avenues. And so now I want to proceed to my second step of the presentation, and this is to sort of apply this to the area of development law studies. And I want to talk here about an area which was perhaps not really mentioned or not as such sort of picked out yesterday in our discussions. And that's the institutional dimension of law and development scholarship. So that's not to talk about institutions in the institutional economics terms, or not in the sense of sort of domestic institutions, but talking here about organizations that or institutions that organize international cooperation for development. So obviously one can think here of the World Bank, but there is a whole range of institutions that fall into that category, or actors. Regional banks, the United Nations, development administrations in donor and recipient countries, if you want to call it that way, NGOs, private banks, philanthropies, you name it. So there's a whole sort of zoo out there of actors and entities. These are having not just influence in the sense of financing projects, but also obviously in the way in framing the way we think about development. The World Bank has been sort of named here very often, but I think other agencies do that too. And what's good for us as lawyers is they obviously operate on the basis of law. I mean, they normally have treaties that set them up. They arrange their deals with agreements. They have internal policies. So there is a lot of material that we can actually approach. So how would we do that? And here I would like to sort of distinguish three different avenues, and in that sort of try to distinguish or combine sort of these different approaches. So the first avenue, the first way of approaching this institutional law of development is actually the nitty-gritty of the law. And you might say this is can be a rather formalist approach. So you can just basically try to understand sort of what are the basic legal structures on which they are based, what are their foundational treaties, how are their instruments structured in the law, so how actually is conditionality, how are safeguard policies, how are indicators structured by law. So this would be a legal analysis of these actors. Now this would be the first avenue to go down. The second avenue would be now to bring in empirical methods, and this would be, in my understanding, mainly sort of a historical perspective and a socio-legal perspective on impacts. So I think it's extremely valuable and important to study the way these institutions have developed over time and their sort of regulations. So this would be sort of picking up on path dependency, on asking sort of what are the activities of them, the mistakes of them, which they might continue. So this you can do in a historical perspective, and you can, in a current perspective, sort of ask in a more socio-legal dimension, sort of what are the impacts. And I think what Kevin Davis has been alluded to several times are actually sort of studies that try to understand the impacts of these institutions. And then on the third level, you can, or the third avenue of analysis, you can sort of try to develop external critical parameters to evaluate the activities and the law of these institutions. And here I would rather draw on political theory than on economic theory. I would rather draw on institutional theory than economic theory, but you can obviously sort of develop your own mix. But you might be able to develop certain parameters like collective autonomy or equity or fairness in order to develop a certain external framework to evaluate that. So this is the my second point, a field of study which I think has not been mentioned enough yesterday, and which might be actually very sort of open to a sort of legal analysis or law and development analysis, which combines legal formalist approaches with non-formalist approaches. Now, third point, and I'm running out of time. What would I suggest, or what are my thoughts about global networks and South-North cooperation? I think this here we have to look into two directions. One is into the north, and one is into the south. In the north, and here again I'm speaking about Germany or continental Europe. The first point is to organize ourselves, basically. There is very little of sort of law and development scholarship which calls itself that way. So I think one real task now is to just bring together the scholars who are interested in that area, and also to offer courses and to offer sort of graduate courses for these themes. So that means to sort of basically develop a community in that sense. Part of that is to work on publications like a journal in order to sort of provide platforms where such scholarship can then be presented. And the other perspective is looking into the north. So what would be my expectations from southern partners? And here I think the main deficit that I see is contact points in an institutional and in an publication sense. I find it really difficult to connect with partners in the South, which would then be my partners to actually develop certain research agendas and develop projects together. So I think there is something to be done there. But also in terms of publications, my sense is that most of the scholarship that we read are published in American journals or sort of at least northern Western journals, and which doesn't mean that in the South there's no publication. I think a lot of that is gray literature and published in organs or in places which we don't find. So I think there we my hope would be to develop more southern publications here. And perhaps we can go also reflect here on who could be partners in the South. Perhaps we should sort of reflect on also the place where we are sitting here, which is a rather elitist place, if I may say so. Sort of who are we actually talking to in the South? Who are our interlocutors? And I think it would be interesting to actually sort of broaden the scope of partners there. Okay, that's what I had to say. Thanks.
Thank you.
Good afternoon. I want to thank the organizers for inviting me to participate in this conference. I'm really thrilled to be here. What I want to do is take the opportunity to reflect on the current state of law and development as a field, and do it in... So I want to divide my presentation in two parts. First, provide this map of law and development mainly in North America, as represented here in this conference in Brazil, and then talk about the South-North cooperation. And I'm going to be talking about mainly the work of legal scholars, not so much the work of economists or the policy-making world of development institutions. And so what I'll do is then provide a map of what I see as the two schools of thought in law and development in the North that are represented in this conference. And I want to offer this as fodder for discussion. So it's, of course, a preliminary map, and it can be the subject to your challenges, adjustments, and further refinements. But I think we can learn something from bringing the differences between these two schools in sharper relief. And I was reassured by the discussion yesterday morning, where I thought that these differences and commitments came to the surface. And so I want to explore what can we do with the similarities and the differences, and perhaps there are productive tensions that we can exploit. So first, I will say there's a Toronto School of Law and Development, and there I would put Michael Trebilcock, Kevin Davis, and Mariana Mota Prado. And then there's a Harvard School of Law and Development, and there I'd put David Kennedy, Kerry Riddick, who renounced her Canadian affiliation, John Onsorg, Helena Alviar, Dennis Davis, Balakrishnan, Rajagopal, and I'll include myself there. And obviously, I'm leaving out a lot of people, and I'm just considering the people who are here. And I'm also not including the law and development sort of movements or schools in Europe and in the global South. Others have done that. I want to focus in North America. And then I see Dave Trubek sort of in between, trying to mediate between these two approaches with a foot in each of these different methodologies and having had an influence in each of these different camps. And it reminds me of previous attempts at mediating, of being a bridge between these movements. Maybe, Dave, you're an incorrigible mediator. But it reminds me of your work on CLS and empiricism, where the action is, or your attempt to mediate between the critical theory and new governance scholarship. So I see this at play, bringing us together and trying to see what insights we can learn from one another. All right. So I want to start outlining some of the differences by referring to the article by Michael Trebilcock and Kevin Davis called The Relationship Between Law and Development, Optimists versus Skeptics, where they reviewed the law and development literature and provided a very useful map. Among the books that they reviewed was the book that Dave Trubek and I co-edited, in which several of the people here participated. And so it's a really fascinating article. A very sort of short summary is there's the optimists who think that law can foster economic development. Many of them are actually in policy circles and in development institutions. And then there's the skeptics who don't think that law can foster development or is associated with economic and social transformation. And this is where they put the book of New Law and Economic Development. And then they situate themselves sometimes implicitly, sometimes more explicitly, the Toronto School, I would say, in the middle, as Michael Trebilcock said yesterday. So they're cautious optimists, or moderate skeptics, if you will. They're attentive to empirical studies, wanting to see what works, and being able to distill some generalizable lessons from developing countries. They present themselves as the voice of reason. That sounds like a really attractive position. I'd like to be in that middle. Institution matters and law matters. However, I always thought that that was a misreading of our position. And not coincidentally, every single person yesterday pushed against that characterization that law doesn't matter, or that we might describe the Harvard School as propounding the view that law is irrelevant. So as you heard yesterday, many of the scholars said it matters, and it matters greatly, just often not in the way that the mainstream policymakers think it does, and also not only in success stories. It also matters in failure. So legal mechanisms, and we hear the stories of development of the Northeast Asian countries and China, where legal mechanisms seem to have played a big role in advancing successful economic policies. But we also heard how law is implicated in regimes of poverty and injustice and racial discrimination. So, and just to finish the comment on that piece, the extreme example provided in the optimists versus skeptics is informal norms, where basically that's an example where law doesn't matter, it's political and economic dynamics that are in the driving seat, because formal law doesn't matter. But the view, I would say, of the Harvard School would be that informal and formal regimes are mutually constitutive, so that in some sense they actually are working and influencing each other, so that informal norms, informality, it's not the absence of law, or it's not a vacuum of law. In fact, you can look at how it's constituted by different legal regimes. And so I thought very helpfully yesterday 3 main themes came about that I wanted to highlight in terms of the interests or commitments of these different schools, the Toronto School and the Harvard School. So first is develop the tools and knowledge that policymakers can use, right? So the promise of empiricism and sound analysis, the interventions on policy making. This is paying attention to what Dave Trubek calls the pool of the policy audience, or the siren call of the policy world. The second is a diagnostic role of how law is implicated in an economic or social regime. So we heard a lot about these yesterday. There's tons of insights here about how legal analysis and critical theory can offer us to do this type of diagnostic. Some of it has to do with social legal research. Kevin mentioned several of aspects of how it'd be important to think not only about domestic law, but about the effect that global frameworks have in particular domestic societies, and not only hard law, but also soft law, so the role of indicators as a governing mechanism, but then also the role that particular laws of strong jurisdiction have in other countries, right? So if we want to focus on human rights, it might be that a better mechanism than trying to make the conventions, the UN conventions on social and political rights or economic and social rights work, we might want to hook it up to a particular strong extraterritorial act. So for example, the US Alien Tort Statute was an example of that type of transnational litigation. Or maybe if we want to promote investment, we might want to see how the US or European tax incentives are working, so that companies are moving their money outside of their jurisdictions rather than keep it inside. So there's many ways in which there are different levers that we can think of as legal scholars to create incentives that we think might be associated with development. One last thing, there was a lot of talk yesterday about labor markets. Again, similar insights that we get from critical theory. It might be that the most effective way of intervening in labor markets might not be reforming domestic labor law. It might be that there are other levers that we can use to think about trade and the pressures that trade poses on the employer-employee relationship and the process of production, or immigration of recipient countries. Or if you think about gender participation, maybe gender discrimination is not the most effective tool. Maybe you need to look at social insurance networks like maternity leave and childcare and how they are structured, or family law regimes and the partition of property upon divorce. So anyway, there are many ways in which you can see law as related to particular regimes, where the most obvious law governing that regime is not the one that is called the labor law or but you get the idea. So it doesn't have to be the law that supposedly regulates the field, the one that seems to be more important. And then finally, the third point is the use of expert knowledge, the critique of expertise. And so here, I'm referring to exploring the ideological and disciplinary commitments of the scholars and policymakers to see how they influence knowledge creation and conventional wisdom. And so I think that whereas the Toronto School seems more interested in the first of these projects, the intervention in the policy world, the Harvard School seems more interested in the second and third of these projects. So then I was looking at the recent work of the Toronto scholars to see what has happened after that map they provided in between optimists and skeptics. So what are the empirically based mid-level recommendations for developing countries that we can get from this methodology? And so I looked at What Makes Poor Countries Poor, a book that Michael Trebilcock and Mariana Prado published, which I commend to all of you. And there is this certainty of, okay, we can get policy recommendations from looking at what countries have done. And so let me just pick three areas where they delve into this. Associated with the neoliberal economic model, and so it'd be interesting to see what the turn to institutions and legal institutions, as they put it, could offer. So in privatization, trade, and property rights. So it looks very contextual again, and there's the recognition that, well, privatization is not advisable in every situation. It has to be country-specific and even industry-specific. It's dependent upon the broader environment in which privatized firms operate. There's an acknowledgement that institutional reforms are key. Establishing competition and securing an effective regulation framework is important. Judicial and bureaucratic reforms, anti-corruption policies. And then there are prerequisites like healthy private sector, effective regulatory structures, macroeconomic stability, absence of corruption. So I would say this is a trope throughout the book. There's a recognition of the need to look for context-specific solutions. The sense that things are very much in flux and are kind of indeterminate because you have gotten good results in some cases but bad results on others. And then these reference to, well, but in any case what we need is a framework of institutions that would make it more palatable or more probable that these reforms would actually take hold, right? And so it's the same in trade, recognizing the huge debate in trade policy and the critique of free trade by Stiglitz, and then talking about the institutional implications of trade policy and the need to have domestic institutional, to have good domestic institutions to make trade work. And again, we get a list of institutions. And finally, in property rights, associated with the regulation, they refer, so again, they show the problems with the push towards formalization of property rights and the push towards private property rights, and they cite David Kennedy's work on some caution when thinking about property rights. So it seems to me that in many of these areas, and I was looking for these mid-level, policy recommendations, and what I found was indeterminacy, and then an assumption that if you move to the domestic legal framework and you have good institutions, somehow these reforms could work, or that this is what we need to pay attention to. And then on Kevin Davies' work, since that piece, had a similar experience. So looking at what I think are Kevin's most influential work, his critique of doing business indicators, taking the measure of law, where he challenges the conceptions of development embedded in the methodology, and then the assumptions of the indicators with the problems of coding, and calls for a better methodology and more research. And then in his article on indicators as a technology of global governance with Kingsbury and Sally Engelmary, where they analyze sort of the modality of governance that indicators provide, right? And challenge the aspiration of neutrality and objectivity of the indicators. And I see that, and moreover, they also show the indeterminacy of indicators politically, right? Because you can have a right-wing or center-right project like the Doing Business, but also a progressive project like the Human Development Index. And here, again, in these pieces, what I saw was a trope where there is a critical analysis of the project and the methodology, and then in the conclusion, this hope that, well, if we do more research, and we can get more sound empirical analysis, and what we need is more evidence and more time, right? And so there's a lot of caution, but the bulk of the work is very critical. And I think the conclusion doesn't really match to the lessons we can derive from the critical work. And then in Kevin's anti-corruption work, well, so after we see what's the transnational regime that regulates corruption, what we get, so I'm quoting here, in the conclusion is, at this stage, it does not seem prudent to go further and attempt to draw any conclusions about whether the anti-corruption efforts of foreign legal institutions have in general positive or negative effects on developing countries. It's unclear whether any general claims would be helpful. It's highly context dependent. And then second, we have insufficient data, right? We need to assess many of the relevant hypotheses. And so I saw, I guess one way of saying, of bringing this to back to the different schools is, you guys are doing critical work too. And in fact, if I base my analysis on empirical evidence, which is the scholarship that you've produced, I would say that some of the most helpful and interesting work has been critical, not interventions in policy making, right? There's nothing wrong with that. And so I guess there is a similarity. I know that my time is running out. Let me just take a few minutes to conclude. So I wanted to rescue one element of scholars in self-entrenchment, which was their attention to the policymakers' consciousness, the idea of trying to map how they think and what are their ideological commitments, which is present, I would say, in the Harvard School, and as I showed, I think, at least in some of the work of the Toronto School. And here I would say, I would credit Michael Trebilcock with having influenced Danny Roderick's idea of the rule of law. So I think that that's a great example of the work that critical legal analysis can offer to economists and policymakers. So here they are running regressions trying to correlate how rule of law is associated with economic performance. Well, guess what? Rule of law is indeterminate. And in fact, there are many competing values at play. So Roderick recognizes that. And now what does he do? He offers this as a much more politicized view of what the rule of law means, shows that there are alternatives and trade-offs between these different conceptions. I think something very similar has been done by Roberto Unger, a Brazilian scholar, influencing Roderick in his idea of how property regimes work. And I see this as a project that David Kennedy has taken up with Joseph Stiglitz in trying to see how critical insights from law can influence development economics. So I think there is a lot of work that can be done here. I wouldn't be worried about the sort of future of the field. I think that the field can be whatever we want it to be. If anything, I think ironically, the South, the Brazilian scholars here are in some sense re-energizing the field by assuming that the field is so important in the North. So I think that there's a way in which all this talk about something called law and development as a field is sort of strengthening the idea that there is such a field and that there are some, contours to the field. I had some things to say about the South-North cooperation, but I see that my time is up. I'll just say three things as a typology. So I think that there are many things to say about how the South engages with the North, and I just thought a quick typology would be, one is to be good students and comply with the orthodoxy. Several policymakers in the South and governments do that. Then there's another possibility, which is to perform as if you comply. There's an emphasis here on performance, so the emphasis is in pretending that you follow the orthodoxy. This is, someone told me in Brazil, called pra inglês ver. The idea that you perform, so this I think came from a moment of banning of slavery, and the Brazilians were sort of pretending they were abolishing slavery for the English to see, but they weren't really, right? And so some of the presentations that we heard on China and the Northeast Asian countries suggest this idea of a cunning state who's playing very well the rhetoric or the discourse of the orthodoxy, but at the same time really mobilizing domestically to do something else, to carve out space or expand flexibility in some way. And the other mode would be direct contestation, so a direct challenge to the North. And my sense is that each country or each group of scholars have to find which of these is more relevant for the kind of political agenda that they would want to push. So I'll leave it here. Thank you.
Thanks. I think the technical term is isomorphic mimicry for conning states. Okay, thank you. I'm going to talk a bit about north-south relationships, I guess, and how I've encountered them through law and development. So I'll talk about two things. One is my work, and then two, how I've kind of tried to approach or research some of these issues. So as I've noted, I work for IDRC. It's the International Development Research Centre. We're a small part of Canada's international assistance. It's about 4%, and we're really built around the notion of supporting local researchers and local researcher institutions. And as I mentioned before, notwithstanding Mariana's and Mario's and Diogo's presentation, we truly believe, and there's a 45-year evidence showing that it's a good way to ensure that research can feed into policy in a longer term and more sustainable way and have a greater effect and longer term impact. And so about 3.5 years ago, I started up. I was given a great challenge. I was given a pretty blank slate to develop a line of research and to support projects and law and development. So we're a granting agency. We primarily give funds and we also give technical support. And they said, go ahead. I was the first in this capacity, and I don't work with other lawyers. And it's an interesting thought process. Where would you start? Law and development, what would you work on? Especially, I was conscious of all the debates, and some of them that we've had in the past couple of days, that it's very hard to say what law and development means, either in terms of substantive normative focus or in which part of the legal system. So my approach, and this may make many of you cringe, is I parked all the big definitional questions at the door. And even in developing some initial strategy papers, I said, there's big debates, we'll come back to them later. And so really, it was a recognition. It has an instrumental value in some cases. It has an inherent value. And I went from there, and with the idea to come back to some larger debates or definition at a later point, and just hoping that, to take Professor Kennedy's words from yesterday, that I wouldn't end up with some crazy weirdo mashup. And I think so far it's been okay, but it takes a bit longer to find these things out. And really, the approach I've taken is, I guess, what you might call more of a problem-focused or an experimental approach, which was to look at issues where people face development challenge, and which either are or coincide with legal challenges, and then to ask, what's the law doing? What's working? What laws are not in place? And, informal and formal, I'm perfectly happy walking throughout them, and the interesting question is how they link up. Many times, different system, and also asking how law might work, and in the process, I've also tried to. So it's research that's by its nature multidisciplinary, and I've tried to straddle some of the contradictions that we've talked about in the last couple of days, and and I didn't necessarily set out to do this, but I think in retrospect, it's not entirely relativist, this work, because I am guided by an optimistic sense that law can play a positive role for development, or you can improve its role. And I come from a donor agency, and we really push partners in research to link up to policy processes, but I'm conscious not to, make it donor-driven, or that, all of a sudden researchers are captive to this push to do policy work because, a donor has showed up and said, well, here is some financial support. So the way we try to do that is then it's really very much for the local actors to define what are the issues and the research questions, and also so that the solutions that they come up with, they generate, speak to the local context. And in the process, it's also a process of building South-South dialogues and cooperation, to pick up some of the themes we've talked about. And this is often done just by bringing together researchers from different countries into one project, or in different workshops, or like we've done here. And it's not a magic bullet, obviously, but it's really a notion that institutions and local actors take the role in defining and leading research agendas. And so the country-specific work is always much easier. The comparative stuff is very hard. One, to draw out similarities, as we've seen in the last few days, but then two, just having people coordinate over great geographic distances. And so, but I think that's the interesting challenge to start from. And as a model for North-South and working along development cooperation, I think it's an interesting one. I think it's an institutional level, but personally it is. And so, you know, I'm always on the lookout for good feedback too. And so there are pressures though, because we're increasingly told to show impact. Again, more and more that it's purely policy relevant. And we're increasingly told to use indicators to track the results. So we're in this audit, we're not immune from this audit society, and everyone wants to know how we can scale out. And if that's a realistic way of doing research or conceiving of the project of development, we can have many long debates about that, but I'll park those questions there. And I also face the challenge, which I've done for a long time, of talking with non-lawyers and convincing them and showing them why is law important or interesting to development. It's not easy, or even, what is administrative law, let alone why this is so fundamental to so many of the issues that people face in any society. And the problem in a context like Canada, we don't have these big problems in our regulatory institutions, so it's very hard to point to problems. I mean, maybe sometimes municipal discussions over a development project, but very hard to show the breakdown in the way that, you see different countries and different contexts dealing with problems where you can say, well, that's a regulatory issue, it's an administrative law issue. And so, and then other, sort of challenges or pressures, donors have this obsession of classifying countries as either lower development, middle income countries, dividing north between south. I mean, we're premised on supporting southern institutions. Is that always a fair way or meaningful way to divide up the world and different people? I'm not sure. I think, as we talked about, there's value to talk about south-south, north-south, and so just some reflections. And the one thing in which to sort of more tailor to this audience is increasingly I have less space to support purely academic research or research that presents itself more academically, and which I think is a shame. And I was very interested and grateful when Mariana and Professor Trubek approached us about this work, because for me now it's very useful to have and to be able to sit in on this more academic reflection about actually, what's the study of law and development at, how's it's progressed, where's the future, and so that's just a note to really thank everyone for so far these very rich discussions, and to commend Mario and Diogo, Mariana, David, for bringing together such a rich and diverse team. So that's part one, the sort of how I've approached North-South relationships in supporting research in law and development. The second is more how I approached trying to teach law and development a couple of years ago, and which was also, it's a process maybe of self-reflection, of experiences working on different parts of the development spectrum, if you want, over a number of years. And so really my approach was, maybe it's more practice driven, but to start with development as the institutional project, in the way that Philip mentioned before, by asking, what are the mechanisms of development and what law applies to that, and is there any law? And part of that, I thought it made real sense teaching this topic in the North, in a donor-based country and context, really to get the students to understand how development works on the ground, and from a somewhat critical way, so that students aren't sort of just exposed to these issues in an idealistic sense or purely defined in terms of its goals. I like to speak more in terms of a sausage machine where good intentions go in and let's see what comes out. And so I think it's an area where, and that's about talking about development as a North-South relationship, as an enterprise, and really trying to understand how is that relationship constructed, where does law come in, and there's very little. And when decisions made is it, policy, is it politics, is it some notion of best practice? And going through different institutional contexts, bilateral, multilateral, donors, and to try to see, how is the relationship structured, and where does law come in, or if it doesn't, what's there in its place? And I think if, just to reflect on some of the discussions about transplantation and different models, development is very, very trend-driven in practice. It works on fads, and that's a lot of times how decision is making, this prevailing notion. So everyone talking about conditional cash transfers the past number of years, go to any large city center and you'll see there's some form of light transit, either buses or trains, and that's to deal with congestion in an era where no one wants to build subways. So that's a debate that's been raging in Toronto for a few years. In most Latin American cities, whether it's Mexico, Lima, Bogota, they have these buses in. They're starting to get them in Africa. That's just either international community practices or decision-making within institutions where it's like, well, let's take this project and that project. I don't think development's much, law and development is much different for a lot of it. There's a lot of, 10 years ago, everyone was rolling out ADR and mediation projects, and that's what they were doing, at least in my home jurisdiction of Ontario. And then they realized maybe wasn't as cost effective as they thought, and and that maybe don't make it mandatory, but maybe it actually works in the beginning. And so the reason of looking at some of the trend-driven or best practice-driven is that a lot of the drastic changes to legal frameworks and regulatory environments, as we've talked about, often happen not in law and development projects or the justice reform projects. They happen in agricultural reform projects or this and that, or different ones. And so it's also the push, maybe to get it slightly larger to understand, how these relationships are structured, where does law come in as a development project is institutional. I mean, I take very clearly from all the country contexts, it's not about the donors defining it in countries like Brazil, but at least to understand those dynamics. And my own interest in, I won't go into full detail for time's sake, is I'm very curious and interested about what are the accountability mechanisms around development. So if you're harmed by a development project or a development process in a developing country, what recourse do you have, especially against this larger administrative or institutional project? And my concern is really, and this is where it becomes very self-reflected, I'm concerned that law development interventions, which is about promoting better laws, and again, it's a very practical notion about promoting laws in justice institution developing countries, I would hate for it to be reduced to a notion of do as I say and not as I do. So, here's a law and development project. Make sure that your justice system is better, developing country, again, whatever that means. But, don't look at our legal processes or the laws governing, because there's huge accountability deficits, which again speaks to what are the relationships. And so I had prepared a paper and which was sent around, which there it's about documenting some of the legal rules, and that's where you bring in a transnational project. So some of it, immunities, is about how different development relationships are structured or international law is structured, which makes it very hard to actually bring a case against donor institutions. Very hard with bilateral governments, slightly less hard with international organizations. And when these cases go before courts, it's much more a discussion about does the immunity prevail or not, and it then becomes a question about access to justice. Then it raises questions about what do these terms actually mean, if you're talking about international rule of law or domestic rule of law. And really, I mean, part of what was so driving this questions is partly normative, the sort of don't do as I say and do as I do. Part of it's just descriptive. I think it's an accurate way of describing how development as a project hits the ground, as an institutional project. And one is that donors increasingly look to domestic legal systems as an almost panacea or a venue for increasing better accountability, regulation of development. So the whole use of country systems agenda, which came through the Paris Declarations, which is about going through countries' environmental assessment processes instead of the international ones to do it. And there's other examples, and that's really about are you looking for an international mechanism or a domestic mechanism to try to regulate? That's sort of one of the policy dimensions. On the other side, then, is also then, again, if you try to trace the paths of how you can get accountability, a lot of times you end up in the domestic courts because you've been shut out of the donor courts or the international mechanisms, or the relationship is structured that way for development. It's done through consultants and the money flows to the government, a recipient government, and so it's very hard to trace any kind of legal liability in a non-contractual, delictual sense, if you want. And so that's just to give a flavor. I don't think I have quite time. I mean, I think for me then, if I look at law and development, some of the practices and some of the thinking about it, those in some are approaches practical ones are some are interesting. I mean, the World Bank has a Justice for the Poor program, which takes as a starting point, let's try to embed a justice focus into an infrastructure project, for example, on the view that the infrastructure project will be better, but then you'll be inculcating better legal norms and processes in the process. There's also the work on the regulatory state in the south, which came out. I know a number of you were involved in, Mariana, Arun, which tried to look at what happened when legal institutions were transplanted into independent regulatory bodies, and they found that they were these empty shells that were transplanted. The larger story there is they came out through structural adjustment programs that came through, again, the infamous World Bank, and saying, well, we need to privatize services. And that's when the World Bank started to do legal and justice reform, when they found an economic hook within their mandate, which Alvaro has talked about in some of his writing, and in a very you've done it very well. And so there they only started to look at legal and judicial reform when it fit their mandate, which is about an interpretation of a legal rule. And then these institutions were transplanted on the theory that it would make better economic reform. But then if the research that's looked at it, what it's traced is that how, in the end, courts have intervened in very interesting ways to help mediate some of the market logics with a more pro-consumer or pro-citizen or pro-rights approach. So all that to say that these projects very much are intertwined. I'll stop there, and it's much more dynamic than just kind of separating out these two. And they're two universes that kind of maybe exist slightly apart. And so all my main point is to say a failure to understand maybe properly those challenges could in fact be an obstacle to the successful regulation of development, that it's very hard to reform justice systems, but it seems to apply just as a prescription. We'll fix the land law. There's a lot of things. Fix the land law, and then we can have good agricultural investment. And conversely, I do wonder whether if we don't take into account the whole institutional framework of development, we're talking about law and development, are we getting a fully robust approach? That's a question I'll pose. And so it's really about trying to, get your fingers dirty, I guess, in all of it, and try to. It's mucky. It's dirty, but I think lawyers do have a good role to bring clarity to a lot of the rules, as Philip has very rightly put. Thank you.
Okay, good afternoon. Let me also thank the organizers of this conference, Mário, Mariana, and Diogo, for this invitation. It's a pleasure to be here with you. Let me start by saying that I'm not a law and development expert. I understand we are all debating what it is to be an expert in law and development, but my background is in international law, and in this context, I do not have a comprehensive study to present here, trying to articulate, I think, good questions related to this North and South cooperation. Is there any relevant role to be played by these kind of global networks? How we can assess their political influence and so on. But I would like to briefly comment with you one recent Brazilian experience which seems to me to be closely connected to the debate on the reach and importance of North and South cooperation, and more especially South-South cooperation in the field of law and development. So just, there's a few information here. I don't know if you can...
Adrian would move a little.
Yeah.
No, you don't have to move completely. You just move toward her a little. Okay.
Okay, so Brazil is currently implementing a robust policy on academic exchange and the so-called Science Without Borders program. According to this, to the official discourse on this Brazilian program, these kind of academic exchanges are aims at promoting innovation in the country through academic exchange experiences, including undergrad and graduate students. So here the idea is, I think it's familiar, but the thing is that I think we are experiencing a very comprehensive policy in terms of sending people to study abroad and all the expectations that are related to this kind of program that those students can come back full of ideas on innovation, and they can somehow reorganize certain contexts that we have here. So just for you to have an idea on the reach of this Science Without Borders program, it was launched in 2011. It's still being implemented. The main goal is to have 101,000 scholarships to be implemented in 4 years. But we have restricted fields of interest, so you can see there is no law, international relations, or social science students included, because the idea is to have the possibility of learning innovation and to bring abroad and to bring back this experience to Brazil in order to have changes in our local context. We have 75,000 scholarships to be implemented with resources from the federal government and 26,000 to be implemented with private resources. But we have around 3 billion reais allocated to this program by the federal government. I think it's a big thing and a big expectation as well. Here, oops. This is how we are today. Lots of scholarships being implemented, this up to October. There is a focus on undergraduate students, on how these young people can come back to Brazil full of ideas and somehow articulate them in our context. But there is also room for PhDs, postdocs, and also full PhDs to be students that can do their whole PhD abroad, but also funding for foreign researchers to come to Brazil and to develop their research here with us. So this is all this information is available in the website, so it's all official, and the discourse is really to show the big expectations that are related to this project. Actually, here, just for you to have an idea, where are our students going? So I think here we start to have a kind of familiar story. Mainly, they go to the north. Let me say that there is no imposition from the government to go to these countries. The student can apply, and he or she has to be accepted in a foreign university. But the thing is that we have this result, mainly a very familiar idea of going to the north, getting expertise, and then coming back, specifically in Brazil, to articulate this here. I think maybe we can go to the map, yes? Better than numbers, just for you to have an idea on the map, how it is today. We cannot see continental Europe because of this blue, so many blue dots. The US, and then Australia, it's here. There's some possibilities here, but so we are not, today we are doing this same movement. Well, I have 3 points here to comment with this map, and then I will conclude. This is a very brief comment, so I will save the time for our whole event. Well, let me first say that I understand that North and South are not dimensions with an existence out there. These are articulated dimensions, but I think we can notice that their articulation is still alive today. I understand in different contexts, but here we do have clearly a picture of how we can have a certain expectation of change, sending students to study in universities in the North. We were discussing about North and South yesterday, so I think this is something that, okay, these are constructed dimensions, but we cannot ignore some movements here. Let me also say, secondly, that this is not a complete picture on Brazilian academic mobility programs. We do have other experiences in law schools, international relations, social science that are not included here. And there are a lot of interesting institutional experiences. Individual one, we have here FGV with the Global League of Law Schools. My university, the Federal University of São Paulo, which is also a new university based on a program of expanding federal universities in Brazil since Lula's administration. So we are also trying to cooperate with Latin American institutions. So this is not a full picture. This is just one context. And we have much more in Brazil. And I think third and more important, I'm not trying here to present any kind of causal relation pattern that we always have the same movement, so that we send students to study abroad in the north. We will have as consequences X, Y, and Z things in Brazil. But I do think that this is a very familiar story to us, to think that we can have change, taking experience and expertise in the north. Actually, I think that we need more time to understand the impact of this kind of program in our reality. We are still implementing those scholarships. It's a big program. And I think I do agree with Alvaro that we may have many ways of engagement between north and south, but maybe we could start to have different, maybe more dots over here and more dots over here, and maybe a more diverse map than this one. So to conclude, I think that if we want to assess the possibilities and failures regarding cooperation, specifically South and South cooperation, as was questioned by Professor David Trubek yesterday, what is happening with South and South cooperation, I think this story has something to tell us about the failures or some limitations. I understand we may have unexpected consequences on this. We do not control the whole process, but I think academic mobility, the way academic mobility is structured and implemented in the South, may be one interesting experience among many others for us to understand the possibilities of cooperation. Oops, that's it. Thank you so much.
Okay. So once again, Jim Kroenke on the faculty here at FGV. So I assume after the 4 previous panelists, I have about 3.5 minutes, right, to keep us on time. So I'll try to do my best. So my presence on this panel, in some ways, my presentation is unavoidably autoethnographic or autobiographical, in large part because I am placed by Mariana in this sort of state of exception and being the northern or working in the south. And when I was thinking about what to say, I was struck yesterday when we were discussing the China panel and the construction of the roadmap as sort of like a history of legal sociology. In China, one of the ways in which you could interpret that is like, who do we want to talk to, right? This is a map of the people and the work with who we want to communicate. And a lot of my own scholarship and work to this date has been critical in the extent of sort of deciding who I don't want to talk to, right? And so, in sort of my own sort of historical study of like law and development, comparative law, and its place in sort of North America, I was, especially as a China scholar, exposed to many bad models of collaboration, right? And so we've talked about this sort of in a positive way, but there's sort of implicit an idea of what the wrong way to go about certain sorts of things. In my scholarship, I call this sort of the missionary model. One of my readers called my most recent book, What's Wrong with America, right? In the sense that there used to be these very popular books about China in the early 20th century that would say, what's wrong with China? What's wrong with Japan, right? And trying to do a diagnosis of the particular pathologies of these cultures. And I think one of the things that's both exciting about being at FGV, but it's challenging for me, is having been a critical scholar, right, and engaging in a large part of my own work and critiquing these sort of bad models, is then puts me in the position now of the sort of much less glamorous work of constructing something positive, right? Participating in putting together a program that's supposed to facilitate not just collaboration South-North, right, but providing a different model of that, right, and implicitly a different model than the one with which I'm familiar with, right? So in the sort of more autoethnographic way, then I often in the last sort of year and a half have had to think much more about what is the nature of collaboration that I want and how to go about facilitating that. So on one level, right, when we talk a lot about sort of who is cooperating, and I think some of us have put emphasis on different types of institutional relationships, right? And I think that's, for anyone who does this type of work, that's a big presence. And it's a big presence not just from a sort of scholastic objective point of view, but because, especially for younger academics, there's an economy of prestige that's involved, right? So when I have representing a particular institution and they want to establish collaborations, right, it's not completely tangential, regardless of people's best intentions, right, that the prestige of particular institutions that's reflected both geographically and within particular geographies impacts that. But the part that really challenges me and the part that I wanted to focus on in my presentation is how to sort of think about what type of scholar do I want to be, and then what type of scholar do I want to collaborate with. This really, when it comes down to it, when you're putting together these types of collaborations, you're really choosing partners, right? And how do you go about choosing partners? And one of the things in sort of evaluating scholars, right, this is really in the sort of the question of who do you want to bring to your institution, who do you want to establish relationships with, is often we've talked about donor funding, right, as having a particular pull on sort of the objectives of these arrangements. But when it comes to individuals, it's much more of like a social and intellectual capital analysis, right? What does a particular individual value when it comes to producing scholarship and the types of relationships it has? So this puts a little bit of a different spin on some of these common topics that people have discussed about what forums do we want to create and participate in, right? What type of products do we want to create, research, publications, et cetera? And then who's the ultimate consumer, right? A transnational consumer, a domestic consumer, and each individual scholar, much less institutions, has a different configuration of how they value these things, right? And they're not necessarily exclusive. But what you also see then is when you start looking at individuals is you see that they operate within these pre-existing collaborations, right? So it's not just that a model exists out there that frames how people think, right? There's a pre-existing set of relationships. So often when people ask me about different types of forums where people engage supposedly in collaborative work, right, there's patterns of exclusion and inclusion, and often people are looking at how to gain access to different types of forms from which they're traditionally excluded. So this is one of the complicated things, and beyond sort of coming up with an abstract model and identifying people to collaborate with, but realizing that for individual scholars, this type of sociological pattern is just as important. So I think this is why when it comes down to this evaluation for me, right, and instead of trying to sort of just reinforce these existing patterns of social patterns, comes down to this question that I brought up yesterday that people often do of method, right? And I think this is why, for me, method is really important when you want to talk about who you're including in different types of groups, right? People have brought up conceptualizing law development as a set of questions, as a set of products. When I do this type of work and I think about, well, I'm at a school that wants to promote law and development, and they want me to bring or help facilitate certain types of relationships, what are the methods that those scholars are going to develop and contribute is ultimately the question I come down to. And one of the interesting things about our discussion in the last 48 hours is this idea of like middle-level theory building, right? And this seems to be very attractive for people. But as I mentioned, as it goes off. Oh, okay, I thought that I was like majorly over already. Okay, this idea of like middle-level theory building, it really comes to like, well, how do you go about this, right? So if we're not just sort of in the missionary mindset where we're sort of trying to intellectually self-reproduce and sort of find other people that have our pre-existing commitments, but we're really open to the possibility that we're gonna engage in some sort of collaborative scholastic enterprise that has the possibility of changing how we think. Right? I think when you're in a sort of prestigious Southern institution, you have plenty of people trolling through, trying to sort of pick up people who will generate empirical information to sort of just fulfill their pre-existing projects, right? This is sort of in the model of people who we don't want to talk to, right? Or I don't want to talk to, or I don't want my colleagues to talk to, right? But then, right, when you say like, okay, so who are we going to generate these middle-level theories with, right? Well, if someone is doing like large N global regression analysis, right? is this someone who we have someone on our faculty who can engage with that type of person to generate theorization that's not going to just be a matter of model deconstruction and reconstruction, right? And I think it gets to this question that's come up implicitly at other times during the conference, is that comparative work is hard, right? Socio-legal work is hard, right? And you put these two things together, right? And then you sort of take the thing that many of us are passionate about our work, and then you trust another person, right, to engage with integrating their difficult comparative empirical work with your own, right? And I think this is where like the self-reproductive thing is not necessarily an issue of narcissism or just reproducing social patterns, but it's very difficult to sort of engage with partners who don't share the same sort of reactions to those types of difficulties. So when you're putting together this idea, and this is something that's implicit in some of the things that were Adrian's saying, is that this used to be, a lot of these things were discussed from a very different point of view in comparative law, right? It's another field that I write about that approaches some of these issues from a very different historical pattern, but there was always this impossibility, right, of the individual having all the skills that allowed them to do all this, right? And this was one of the things where how could I possibly do this, right, on a collaborative basis? I'll just try to gather all the expertise myself. I think the move towards interdisciplinarity, just generally speaking, has pushed people to really realize that teams are necessary, right? Not just for dispositional sort of like amplification, right? For the fact that you just don't have the skill set to attack these types of issues in a way that would allow you to do this type of collaborative middle level building, right? Again, that was open to sort of self-reformation, right? The whole idea is that you're going to engage in something constructive and critical with the opportunity or the possibility of changing how you think not only about some other foreign legal example, but about your own particular pre-existing set of commitments, right? So I think this presents two consistent challenges that I don't have particular answers to because I'm always sort of running up against my own critiques when I try to put these things together, and that is you can really sort of focus in on the sort of the methodological compatibility, right? And I think this is really, when Marta was talking about legal anthropology, I mean, anthropologists love to talk again about these things, but it's really hard to get two anthropologists together to actually work together on one of these types of projects because they have such different views of even what it means to do like field work or something like that. So I think in selecting these types of collaborations, I think one of the real emphasis is going to be on finding these sort of patterns of methodological integration. The other thing that I think, you know, from a certain perspective, sort of, again, gets at this sort of falling into the things that I've critiqued, is that it's very difficult to do this while pretending that you're not just trying to share a normative agenda with people, right? You're passionate intellectuals and scholars, you commit your life to these types of ideas, and then the idea that you're just sort of going to be like, and I just want to promote this as a general concept, right? And sort of let anyone in, even if I have sort of like diametrically opposed personal or intellectual commitments is difficult. So there's sort of like two ways in which I've tried to sort of honestly think about this idea of facilitating these collaborations, again, on a constructive, positive model, and that is just creating open spaces for cross-fertilization, right? And I think that in of itself is difficult, right? But that's sort of like, I'm just going to try to completely hands-off. I'm not going to try to reproduce my own existing social and intellectual network, right? And then sort of see what happens, right? And this is, as Adrian is discussing, this is difficult because it's very hard to see that all the effort and energy that's put into such a collaboration actually leads to something, right? Because there's a way in which you're sort of going with, are we doing 15 minutes? Oh, I thought we were doing 10. Okay, I will slow down then. Okay, sorry.
Just don't go to 20.
Right? No, that's not going to happen. So there's this one thing of just being honest in the fact that you're going to just try to engage in something that facilitates your own personal project, right, as a scholar. And I don't think that as much as like that trends with these types of things that I critique in my own work that sort of fall under the rubric of like legal imperialism or so on. But I think that's sort of like the most open way of saying like I'm just looking for some other group of people, right, where we have enough synergy that we can engage and produce something that we couldn't produce ourselves, right? And the fact is I can't do that with people where there's a large level of dissonance, right? I think this comes up, for example, in one of the other fields that I've participated in, which I mentioned earlier, like comparative constitutional law, right? Even though it's something that I have engaged in and that I've written about, I've tried to put a great deal of effort into engaging with people who have a fundamentally different view, right, of what that means as a methodological, right, and normative enterprise. And at a certain point, you sort of have to sort of look at the marginal utility of your own time and effort in trying to make things work that sort of don't jive on these particular types of levels. So I think on an individual basis, right, that's sort of one thing that you have to struggle through. And then so when you go on sort of on the institutional basis, right, and you're trying to sort of not sort of just have your institution push you towards things that satisfy its own sort of desires, again, to generate social capital, I think you have to push much more for the second model, which is sort of just like the open cross-fertilization, which I think is, especially as a young academic, is like the worst for your own career, right? It doesn't give you naturally enough. It actually makes you agitate against, again, what's valued by your institution. But it also is probably the best way of opening up that possibility for self-reform, right? The sort of collaborative model that's pushing towards a shared goal makes that increasingly difficult because people amplify, again, your own preconceptions, but you have to sort of let that go if you're really going to open up the space for your participation to change you, even if, right, you're doing different types of models of collaboration. And I think this is, again, shaped by my own experience of the North. I mean, it sounds just geographically weird for me because I used to think about and still think about U.S. and China and U.S. and Brazil, and it's like a triangle. But in this sense of sort of like the North-South dynamic is that I think people have seen the pitfalls of sort of like the facilitating the personal project, right? And they've sort of given pans to sort of opening up those spaces of cross-fertilization, but it's been much more difficult in practice to put those things together. So I think one of the interesting things in the coming sort of years and sort of in this particular institution is how these things will evolve and how much they'll be able to sort of shatter these old sort of patterns that Fabia relates here, but also leave something tangible in its wake besides more sort of like cosmopolitan invocations of participation, but that really this leads in some way to better scholarship and better working relationships between institutions and legal cultures. That's it.
Thank you so much. Thank you to all the panelists. I would just acknowledge that Fabia used 10 minutes, so I will transfer those minutes to Alvaro, who was over time. I'm not sure if this is South and South Cooperation. I will claim it is. So let me kick off the questions by asking a few questions, and then I'll pass the mic around. I will aim for collecting questions for 20 minutes and then give 10 minutes to the panelists to address the questions, some of the questions, not all of them. So let me start by just asking Philip and Adrian, who are proposing this very interesting, I mean, Philip is proposing it, Adrian has subscribed to it and has implemented this interesting analysis of the law of international development organizations, right? And you both are teaching this in the Global North. So my question is, when we are talking about the potential policy implications of academic work, do you think this could be the most effective way of promoting changes? So some of your accountability concerns, do you think they're going to be fostered more strongly by the students coming out of law schools in the Global North, or should perhaps we be thinking about, you know, proposing to Mário here at FGB to be teaching this course, and the representatives of Brazil will be fighting for this in the global sphere. Alvaro, regarding the Toronto-Harvard School, I'm glad that you're trying to sort of find commonalities, but I'm just going to push back a little bit to ask you one thing. I think you are sort of saying Toronto has been critical, and we have, but I think perhaps one of the way people perceive the distinction is that we often land on some sort of concrete policy proposal, right? So the beginning of the analysis is always critical, what went wrong, how we can possibly explain what hasn't worked, but then I think it's the last move that the CLS has not been so overly concerned with, and we are always trying to get there, right? So I was wondering if you could talk a little bit whether you think this last move might set us apart again, which would be unfortunate, so I hope your answer is no. Fabia, my question to you is, to what extent the dynamic you're identifying is because it's science, right? So when we talk about South-South cooperation in development policy, you know, we're looking at participatory budgeting and, institutional innovation. But if we're talking about patenting, the U.S. is still the country in the world with the highest number of patents per capita, right? So, I was wondering if you could talk a little bit about that. And Jed, fascinating account. I was just lacking a concrete example of what you're calling open space for cross-fertilization. If you could give us a concrete example of what you mean by that, that would be wonderful. Okay, I'm walking around passing this, or I'm just going to pass it around. Kevin is the first person, and then just raise your hand. I'll be back here.
Hi. So I'm not actually going to push back, Alvaro. I'm just glad that at least someone's reading the papers. But I guess what I'll say is you're probably right about whether about the critical aspect of the work that you cited, but I think that in part reflects the difficulty of doing the other kind of work, the difficulty of being constructive. So in the anti-corruption work that's about to come out, I was working with some folks here and in Argentina on anti-corruption policy, these case studies, and it took us 6 years, or it has taken us 6 years to get a paper out. And that, that involved a certain amount of empirical work, but just on 2 cases, 2 legal proceedings. So it's an example of north-south collaboration, but it actually is very, very difficult, just to underscore the point that Jed was making. And so I think, but I don't feel comfortable making any concrete statements about policy without having gone through that kind of work. So I think that's part of what you're seeing. It's easy to be critical, much harder to be constructive in that kind of way. A couple of other comments. On the teaching front, I do think it's worth thinking about the value of teaching law and development, or ideas about law and development. And what we've heard so far seems to have been premised, from Philip and Adrian, and even from Mariana, seem to have been premised on the idea that we're teaching students who are going to go out and do law and development work. That's going to be their primary occupation. Recently, actually, I've stopped teaching the general law and development course, and I'm teaching 2 courses I think of as being related to law and development, one called Financing Development, and the other is my anti-corruption course. And they're aimed more at just sort of general practitioners or general corporate practitioners who I think it's valuable to have sensitized to this kind of work. So I actually think there's a lot to be said for making sure that the project finance lawyers in New York have some sense of the ramifications of the projects that they're financing from a development perspective, or the anti-corruption lawyers who are generating these compliance programs for firms understand that it may not be the best idea to advise your clients just to cut off investment in, say, Nigeria in response to the fact that it's a high-risk jurisdiction. That actually might have implications for the development prospects of the country. So just in terms of the teaching side of things, I think it's worth remembering that it's valuable not only to preach to the choir. So third, relatively personal reflection, just in reaction to something that Jed said. I'm not sure where you came out actually in the end in terms of the value of speaking to people who share methodological commitments. So again, just from personal experience, I get a lot out of jumping around in terms of my methodology. So on the anti-corruption side, the pieces that are coming out are very qualitative, based on lots of interviews and so forth. It's good to have very diligent co-authors in that respect. But I just published a statistical analysis with lots and lots of regressions, and the next piece will probably be a formal model, game theoretic model. There'll probably be a lot of math, and actually I think it helps to attack certain problems from multiple perspectives using multiple methodologies, and of course to speak to collaborators who can help you with each of those projects. So.
Just a brief comment in passing. I want to distinguish between 2 things that are easily conflated, but very unfortunately conflated, in my view. And that is the distinction between criticism and critique. Criticism, as in being negative, deciding or characterizing something as a bad thing for one reason or another, is a different thing than the critical enterprise, which involves uncovering, excavating the foundational assumptions on which regulatory projects are built and considering their implications for different purposes. I think the critical tradition in law and development, as in other forms of legal analysis, is properly understood as the second, not the first. It may well be the case that critical theorists or critical analysts sometimes disparage or disapprove of various programs, but the critical enterprise is about understanding the foundational assumptions on which programs are organized. And this is the German, the continental understanding of critical work. And so I want us to bear that in mind because I think it's quite important.
So Alvaro's description of two tendencies, which I am going to not relate to locations where the temperatures are very low right now, since that seems to replicate one of the problems we're trying to get around, which is North domination of the South. So I'm going to call it programmatic and critical in the Kerry sense, the programmatic school and the critical school. And then there is then, on top of that, the North-South distinction, that is, people in the North who are a little uncomfortable because they don't want to be legal imperialists, but they want to be useful. And people in the South who don't want to be just clones of some northern school or scholar, but feel a little uncomfortable because they understand that in order to be effective in their own communities and contexts, they may have to speak with at least a northern accent as they discuss concrete problems. So there's a fourfold table here. There's the programmatic and the critical and the North and the South. And it seems to me that the test of whether we can move ahead as a group that embraces these and many other dimensions, but for a short comment, it's hard to deal with more than 2 dimensions, is whether we can live in the contradiction. Because the real challenge is to be able to live in a situation where these competing positions and approaches are all in play, and we can keep together while still having these separate identities. This is what, in a way, Jed was trying to say. I do agree we need a concrete example or two. So living in the contradiction of North and South critique and program might be the test of whether there is a field, whatever we call it.
I was just going to offer an observation that, based on comments that have been made casually here and there, on the difference in the, I think, the larger environment, scholarly and policy-wise, surrounding law and development 1. This is the scholars and so estrangement moment, and law and development 2, the Trubek retrospective. And that is the international environment. I think that it's vastly different today than it was 40 years ago. I mean, I teach international trade law. Most countries in the world, including China and Russia, are now members of the WTO, which includes, of course, the TRIPS agreement. So that, of course, implies very substantial harmonization of intellectual property laws, along with many other domestic forms of regulation. We've seen with the global financial crisis of 2008 a need for very substantial international coordination of macroeconomic policy. Climate change policy we can't make any progress on without substantial cooperation. So whether it's north-south, south-south, I think the domestic policy space is for all countries, north and south, is increasingly constrained by the international uh, economic environment and international legal environment. And you can throw in as well the internationalization of technology, including IT. And this is a very different world from the one that David was evaluating the feasibility of comparative law and development studies 40 years ago. I mean, this is night and day different.
So I guess it's my job to make people nauseous again. One of the things that's been bothering me about this panel and the last panel is it seems to conflate two different ideas or conceptualizations of law and development. One is law and development as an intellectual project, as something that we investigate, maybe if for no other reason than because we're interested in it. There's also the idea of law and development as a political project, having a law and development community, having effect on policy making. I think these have been conflated, which kind of bothers me a bit, because not only are they distinct, but they're in many ways, they can be in tension, in that choosing one involves pushing away the other. And I think the best demonstration that I can make of this is by contrasting the presentation by Philip Dan, which I very much agreed with. I'm more on the intellectual side. And then the presentation by Alvaro's, which, quite frankly, scared me.
Good.
So, I'll tell you why. So, Philip made a very important point, that if we're talking about law and development as an intellectual project, law and development is all around us. I would take issue a bit with the claim or the complaint attributed to David Kennedy about we don't want law and development to be everything. I think it is everything. That's where we're going to find it. Everyone who makes a critique of law is doing something about law and development. And I think Philip's point is that when you look at Europe, you have lots of people doing law development, but they're just not at law schools. I can think of Bob Jessup, who does post-Fordist development in Asia, but he's a sociologist. Sean Breslin, who does law and development in the context of China, is a political economist. So you find it in a lot of different places. You don't necessarily find it in law schools. And this is why I think if we're thinking about law as an intellectual endeavor, then everybody does law and development. And our job is to find the people that are doing the work that is relevant to what it is that we're trying to understand. Which gets me to Alvaro. I am not from Harvard. I am not from Toronto.
Not too late.
Yeah, I am 55 years old. It is too late. And so I'm wondering if that's where law and development is, if it's those two schools, I don't feel like I'm a part of it. I know lots of people that do really incredible work in law and development that aren't part, that you've never heard of. I've absolutely, Fred Deo does some wonderful stuff on how labor regimes in Japan affect labor regimes in Thailand through production chains. Kanishka Yarasuria at Adelaide. How does Adelaide fit in the Harvard versus Toronto? The work that comes out of Melbourne looking at Southeast Asia. John Gillespie's stuff on Vietnam. There is, and maybe it's because of my experience with American law schools, but I worry about the political side of law and development because it just makes me wonder if I'm going to be included. And I know people, I have a colleague who does incredible work on comparative corporate governance who expressed, and I said, you know, what you do is very much related to the relationship of law and development. He goes, yeah, I know that, but I've been to some conferences about law and development. All they talk about is what doing law and development is. They never talk about corporate governance. So he feels excluded. So this is the concern I make. When we start identifying law and development with particular elite institutions in a very narrow geography, then what about those of us who are not a part of those communities and that aren't regarded as elite institutions by those communities?
Thank you. So, oh yes, I forgot Mario. Last question.
Okay. I'd like to go back to this debate, not exactly a debate, but this conversation between Fabia and Dave, the question asked by Dave yesterday. Fabia presented a very interesting map showing that despite our preferences, the preference of Brazilian students is to go to US, Europe, and consolidated center in the global north, not to the global south. This problem could be easily corrected by using public money or by public policy, which could be a kind of incentives to driving these students to the south, not to the north. But my question is it desirable? Considering that the public policy deals with budgetary constraints, what is the best allocation of public resources in Brazil? Is to send the Brazilian students to very consolidated centers in the global north or to global south? I'm very in favor of South-South cooperation, but I'm just emphasizing here the constraints of this kind of policy.
So I'm going to give each of you 2 minutes, if I may. So we do 10 minutes of answers and then the break. Yeah, so let's follow the order.
Yeah, I just react to yours, actually, Mariana, and Kevin's question about the policy implications of teaching, not perhaps law and development, but in this more narrow sense, law of institutional institutional side of development cooperation. I don't think. So far I don't know what the policy implications are because I just started teaching that. But the intention is not to have policy implications in any substantive sense. The intention is to basically enlighten or sort of understand the institutional system and sort of provide young people with knowledge about the institutional system that they might later have to navigate. And this is, I think, sort of relevant for many people. I mean, it can be people like Kevin talked about who are not really engaging with this world at all directly. Then it's just a knowledge about a really important policy field and institutional structure. But it's also about sort of educating people who might engage in that area. And my observation so far is that sort of people in those institutions, be it in the banks or in NGOs or wherever you want to look for them, are very often really not knowing sort of anything about the institutional system. I mean, there's really a huge gap of knowledge of how this system works legally. I mean, obviously there's a lot of political analysis of the system, but from a legal perspective, it's difficult. And so in that sense, I hope that this kind of sort of scholarship and teaching provides a more sort of a better and clearer understanding of how the system works.
So thank you for your questions. Mariana, so I'm not trying to harmonize the two schools that I identify. I wanted to suggest that there's a lot of critical work being produced by the Toronto School that I think probably it's not understood or admitted as such. But I think that I also wanted to highlight the differences and the tensions between what the approach suggests it's doing and what in fact is doing. So in terms of the policy proposals, so you say after critique come the concrete policy proposals, and that's what I'm more unsatisfied by, because the concrete policy proposals reproduce a set of general recommendations that seem to me to be not necessarily very helpful or insightful. So, build up legal institutions like, for example, have effective bureaucracies, effective courts, anti-corruption mechanisms, and so forth. They seem to kind of go very well with the good governance agenda that has been recommending this for a long while. And there are problems with that agenda in terms of obscuring or not paying attention to the current arrangements that underpin, some of which are legal arrangements, the established social and economic order, and what might be possible solutions to disrupt them. And so I think that almost over and over again in that book of what poor countries, why poor countries are poor, there's this sense that even though there's indeterminacy in the empirical evidence, there's a faith in these general solutions as a framework that will do the work. We just don't know how, and it really sounds more like a faith. And it sort of reproduces or mimics the institutional setup of the North without actually figuring out why were they relevant and how they came about. And so that's my critique and my worry. Kevin, so yeah, I would agree with Kerry Riddick. There's the difference between being critical and critique. I would say, so you suggested it's difficult, it's harder to do, to be constructive than to be critical. I guess it depends, or to do critique. It depends on the project, right? There's a wealth of constructive work that seems to be very easy, but also very unhelpful or even harmful. And there could be a lot of critical work if it manages to dislodge very entrenched assumptions and to challenge them and to politicize the results of those projects. They might be actually quite positive, but it's hard to do that type of work as well. It requires a lot of engagement, a lot of going against entrenched conventional wisdom. A lot of it might also entail qualitative research. So I wouldn't draw that distinction. I think it really depends on the project. And then going back to your work, so it seems to me that in the conclusions of these articles that I was referring to, there's a risk that we believe that if we only keep working towards sounder analysis, somehow we'll be able to find the answer, right? But if you follow that line in the work of indicators, for example, which, as you said, you recently started asking, well, who's behind these indicators and what are the normative implications and what are the political projects, you'll miss that, right? So if you just dive into, okay, what's the empirical work and can we challenge the methodology and so forth, it will be harder to contest the normative implications that work has and the political valence that it comes with, right? And so I think that you need to be attentive to both. And the idea that as long as we continue doing empirical work, we might be able to get to a right or correct answer on whether a given institution works or not, might miss that other insight in your work, which is that there are really contested normative views in the priors of these indicators, and it's important to be mindful of them. Work in economics has made this very clear, I think, in empirical work, right? So in the United States, the work of law and economics scholars like John Donahue has really almost suggested that there's a new legal realist moment in economics where a lot of the empirical work is basically lining up against each other depending on your priors and assumptions, and it's hard to adjudicate between them, right? And so I think it's important to be conscious of what those normative commitments are, and I hear the hope or the faith that as long as we continue doing work, we're going to be able to get a right answer as maybe an illusion or problematic. Not that empirical work is not helpful or necessary or could be very concretely so tied to particular projects, but as a general sort of predisposition, it seems like your own work suggests that that might be, unwarranted. Then on Michael's comment, so I agree that the international environment has changed dramatically. Just to take the question of the WTO and trade. So there, for example, I think there's an enormous opportunity for legal scholars to try to analyze and bring insights of law and development into the trade arrangements. And it seems to me that that is something that development economists are not very well equipped at because they don't understand the way in which the way in which the agreements have been mobilized and interpreted by the panels and the dispute settlement, and also the way in which the actors are strategizing about it. But it seems to me that in the book, for example, all we get is a recognition of the asymmetries and an emphasis on special and differential treatment, and maybe even in making trips optional, right? Which I think is really a great point. But it seems to me that we miss the opportunity of exploring how we might experiment with different market arrangements underpinned by trade law. And that there's an opportunity there to connect with development economists to try to figure out how we do that based on the concrete experience of countries that have achieved high levels of growth using trade mechanisms. And so it seems to me that if we just take them for granted, which seems to me not all, but much of what happens in why poor countries are poor, we miss a very important opportunity. And then finally, Michael Dowdle. Well, you just had an invitation to join the Toronto School. No, I agree with you that this is obviously an incredibly partial view, and I don't for a second suggest that this is comprehensive. In fact, it's incredibly idiosyncratic, and it's just very partial. I suggested that this was basically a map of the North American field of land development as represented in the room, but you're entirely right that there's a lot of work that's incredibly valuable that is being produced in other geographies, and that'll be good for us to pay attention to that. I also didn't mention how much work it's being done here, and the efforts to build up a land development hub, and the work that Mario, Schapiro, and Diogo Coutinho are doing. So I think that's, I'm the first one to admit, but I wanted to illustrate the two schools and also show their tensions. Thanks.
Just to first answer your question about whether it'd be valuable to teach some of the regulatory or law of development in Brazil or Global South, I think yes, and for slightly different reasons. I'll give one anecdote. One of the topics I taught was sovereign debt, and there's these vulture funds. So Zambia got sued for $42 million on debt that was going to be essentially relieved, erased, by Virgin Islands companies that bought the debt for, I think it was $4 million from Romania. And so when I was preparing, this is very anecdotal, I was preparing the syllabus, I was talking to my friend from Zambia who's a lawyer, and I was like, by the way, I'm going to be teaching Zambia. And she's like, oh, well, when you do that, tell your students that's about legal capacity building. And I said, what? And she said the backstory was it was her old classmate who worked in the ministry and waived, I think it was immunities or whatever procedural block that could have thrown the case away, but they didn't know better. Now, I don't want to, with a brushstroke, paint an overly negative picture about one country in particular. Zambian lawyers, you have very good lawyers in every country, but there you go, that there was less of a legal infrastructure to handle the cases, and then it became, and it's a topic that raises huge questions because the legal frameworks are very clear and strong about enforcing sovereign debt, and unless you're Argentina, but then it raises questions about, is the development equitable? Is it working in the right way? And there's a specific example. I see it now very much around land issues, where we're working with groups in Senegal, and the World Bank has brought in a new project for sustainable, inclusive agribusiness, which is going to, as part of it, they're going to pilot a new investment framework for land, very investment friendly. And some of the groups we work with were consulted as part of a social safeguard assessment process, and they had kind of reservations, and they don't fully quite understand the land work of the sort of landscape of the different processes and how they fit into a larger decision making, or I'm not sure if they quite know what an inspection panel process would look like, or if it's relevant. And what we've been doing is they're doing very much underground research that can feed into, are these processes working for the communities process impacting? And that's where you get also then the policy, just to switch gears a bit, the policy research angle. How do you engage, be constructive without being co-optive, still maintain your objectivity? We have huge questions, but there, if they had greater awareness, I think it would help, because you hopefully even the playing field. Specific to Brazil, I think it's a different dynamic, because then you have to ask the question, how reliant is Brazil now on foreign debt? I mean, from multilateral, bilateral donors. I think Brazil is much more a country that reaches into the regular financial markets internationally and is becoming a donor itself. And so I think that's where there's an interesting moment of this sort of between roles, and then how are they going to chart their future as a donor, and then look at northern models, and then bring in the healthy critique. And then just on the thing of law and development is everything, I'm fully comfortable saying that, because development's everything, and that's where, and this is even discussions I have with students, north, south, rich, poor countries, we're always talking about growth, and we're always talking about changing our lives. And then you get into different discussion, and that's where I really focus on then what are the priorities being set as an international development agenda, who's dictating on what criteria. The last year, everyone's been talking about a post-2015 MDG environment. The Secretary General released a report, synthesis report on Thursday, talking about, which is going to serve as the basis for negotiation for development priorities for the next 15 years till 2013, and that everyone should live with dignity is the sort of title. Justice made it in. Initially, access to justice as an indicator, and that's what the MDGs were, indicators. And now in the synthesis report, it appears as one of 6 themes. This is what all the donors who fund this work have been worrying about and talking about. Not so much because we're more on the periphery, we're doing other stuff, but those are the discussions also we try to follow. Paragraph 50, because I was reading it earlier, talks about their conception of justice. It's not a thin notion of rule of law. It's a liberal democratic one if you really push it, talking about civil political rights and different things. That's what's going to do. And so not that as researchers, academics, one should be beholden to that, but it's then being sort of conscious that it's everything, but then it's not, because a lot of times, as an enterprise, this is how the priorities are set, and it's a political process. Law may come in as something, but it's not the main story.
Okay, so thank you for your questions. Well, Mariana, I'm not saying that we have to abandon the engagement with the North. I think we do have, and to think about it on how to deal with this, why our students want to go to the same places we all know, and maybe I do believe that we could have different spaces and different experiences because we need to meet and we need to talk. People from Brazil, Russia, and India, or the BRICS, and people from Latin America. It's just that, and this leads me to Mário's comments, we are not sure that this is effective, that this is going to produce the expectations that we want, that they are going to bring innovation to Brazil. So if we are not sure, why not to have some space for experimentalism? So if there is uncertainty, I would think of different spaces for cooperation. Yeah.
All right, so as for just go straight to examples, and I think this is somewhere sort of in between Kevin and Dave's question. There's in the two examples I'll use is one is so an exchange is proposed between home university and another university, right? And so you're tasked with constructing what sort of is the purpose of this exchange and then how to go about it, right? So this is sort of the success story in the sense that I had another collaborator who was willing to sit down and say, like, well, let's read the papers of the people we know at our particular institutions. Let's see what they've been working on recently, and let's try to play matchmaker, right? This requires an investment of actually reading their recent scholarship and not just sort of like, anonymously requesting commentators. We have a paper, and here's a commentator. Because that may be nice, but what we're trying to get as the end goal is some sort of research collaboration, right? A longitudinal engagement, right? Not just an episodic, interesting, one-time interaction. And while there may be some individual sort of analysis in that, like not everyone is as methodologically Catholic as you are and has the capacity to work with a wide range of people. And part of that, right, the matchmaking process is knowing those types of dispositions, right? And knowing whether people are open to comparative work at all, right? It doesn't mean that they have to have done it themselves, but let's try to find people that we think are actually going to be in conversations after this, right? Because the whole sort of genesis of the exchange is two high-profile groups of people sort of exchanging their social capital with each other. Once we satisfy that, can we actually do something more with that that's going to lead to this different type of research project, right? So that's one mode where you're trying to generate, right, this sort of like value add in that context. The other suggestion, and this is in response to Mariana about sort of the open field. So this is the failure, right? So this is having funding for a particular type of conference and offering the particular characteristics that ended up not being persuasive, right? Inviting people that you don't know, Having people present on the same panel with multiple methodologies, right? People from multiple applications of knowledge, right? Academic, policy, openly broad themes, right? Without having to establish that people, like I guess this is sort of implicit here, right? Belong to a coherent field of analysis. Doing what I call, I mean, to be honest, sort of like, and this is getting to Michael's point, right? What from the institutional point of view is going to be low status bets, right? This is, again, inviting people you don't know, but inviting people based upon reading their scholarship. And that's pretty much it, right? Was the model. So the idea of this was to bring together people who normally don't, fall together in the social patterns of academia, right? People who come from things in a way where we're not trying to sort of necessarily generate research patterns, so there may be some natural dissonance that generates the type of sort of like unpredictable outcomes that don't lead to necessary sort of payoffs, and doing it in a way that, I mean, this proactively disrupts the same types of, again, social capital patterns that I think plague a lot of international exchange, even when they're guided by the best of intentions, right? So those are two different types of engagements, and those are just particular qualities that conceptualize in putting those together.